Parasites. Every single public servant here is a parasite. And now I'm in this toilet. Look at the...
It's going to go and get security.
Hey, really? What are they going to do?
Good morning, people. So, as I was at Auckland District Court last week, following another story there with what's going on with Jamie, I did recording then. So bear that in mind. I decided, because Georgina had sent me an email telling me that that the time had been changed to a different courtroom, different time, to let me discuss about recording. Now, I'm going to court. I was given a request to attend. I'm going to court to discuss an allegation against my Sister Q Trust, or Sister Q Trust, from New Zealand Police. I'm not going there to discuss my rights, which I'm going to be exercising. It's a right. I'm not downgrading that to go and ask permission from someone who thinks they have greater authority than me. We're all equal, people. No one has greater authority over myself than me. I'm an autonomous man. It's that simple. So, to move on, what I did is I sent Georgina Dawson an email yesterday, Monday, the 10th of July, and sorry, it's a little cold, so I'm shivering. And I sent her this, and its subject matter is confirm reason for attendance, please. And I gave him the court reference number. And what I've written here is, good afternoon, Georgina. We hope you had a wonderful weekend. Could you please confirm the reason for attendance at ADC, or Auckland District Court, Courtroom 2 at 2:15 p.m. on the 13th of July is to address the allegations by New Zealand Police against MDE Keen. According to your correspondence thus far, it would appear that ADC has placed us on a judge's list for what you stated to discuss recording. Is that correct? We wish to confirm that our attendance will be to address the allegation made against MDE Keen and not the previously notified intent to exercise rights affirmed, to which ADC confirmed by acquiescence and failure to supply reasoning or evidence as to what is there to discuss with regards to us keeping record of any kind in any form. Notice, our attendance will be to seek the nature and cause of these proceedings as to make a fully informed plea. Evidence of any jurisdiction the prosecution has supplied to Auckland District Court, such as statement from the paymaster, timesheets or proof of payment that we were employed in their jurisdiction at the time of the alleged offence with regards to this matter, will be required. Two questions we do not hesitate to ask is, 1. Please clarify what is a judge's list. 2. Is this preliminary hearing not to establish jurisdiction? Notice, our fee schedule previously supplied will be activated and applicable. See Services to Others and or Corporations, Section E. Should Auckland District Court or any member of the judiciary wish to discuss the exercising of rights previously mentioned and affirmed, Auckland District Court shall be liable for any out-of-pocket expenses for any time used in discussion of any nature of any matter other than court reference number 1700 417 6889. failure to respond to this notice prior to the 13th day of this month, July, in the year 2017, shall, in the absence of evidence to the contrary, be construed as contrary to your earlier position, and that this change has occurred to allow you to discuss your wish to digitally record the proceedings with a member of the judiciary who has jurisdiction within this area. In the interim, no agreement has been made by the Auckland District Court regarding the recording of the proceedings, and you will have to address this on the day with the presiding judge. Notice: no allowance was requested by us to discuss recording the proceedings with a member of the judiciary. Notice of intent was given, to which no rebuttal has been received to this date. Only suggestions. Warm regards, me. Okay. Georgina replies yesterday, almost 2 hours afterwards. Good afternoon, Mark. Your attendance is required for the purpose of taking your plea, and this will occur within the judge's list. The purpose of the judge's list is to act as a court of first appearance before a judge. As you wish to record this hearing, it is best discussed with the presiding judge, as it is within their jurisdiction as to what can and cannot occur within the courtroom. Therefore, if it is decided on the day that you are not to record the proceedings, then that is what is to occur. As previously stated, Auckland District Court has not entered into any agreement regarding the recording of the proceedings, and you will have to address this on the day with the presiding judge. No recordings are to be taken prior to the discussion occurring, and the ability to record is dependent on the outcome of said discussion with the presiding judge. Kind regards, Georgina. So, it seems to me now that they're telling me that they're just ignoring the fact that I have a right to record. They're ignoring the Bill of Rights, Section 14, and they're just saying, you do as we say. No, doesn't work that way for me. Sorry. I replied to Georgina with, and this was at 1 o'clock in the morning when I got around to doing it. Good morning, Georgina. We are aware our attendance is requested, not required, as we have the ability to file an appearance without even attending on the day. Given that you have failed to answer whether you are legally trained or not, we will presume you are not by your previous responses. How is it that you have not mentioned that a request to record should be submitted prior? Were you unaware? To clarify, we will be at the courtroom, not in it. Where does the unnamed mystery judge derive their authority over us? We can appreciate your suggestion as to what is best. However, we have now given Auckland District Court multiple opportunities to supply reasoning and or justification as to the prohibition of rights affirmed or infringement against such, which you have not done. Again, can Auckland District Court supply any evidence of where the mystery judge derives authority over the exercising of our rights? As to your comments that no recording are to be taken prior to this discussion occurring, please explain. Is Auckland District Courthouse not a public building? Our ability to record does not depend on the outcome of any conversation. It is a right. We shall exercise it, as we have done many times before at courthouses. The judge may have jurisdiction over allegations and matters before the court, not over our rights we wish to exercise. As all are equal, the presiding judge has no greater authority over us than we do. We hope this is crystal clear, Georgina. Just last Friday we exercised our right to record freely at Auckland District Court for some time.
Parasites! Every single public servant here is a parasite!
And this was not the first occurrence, as there is no expectation of privacy within public places, nor for those acting as public servants such as yourself. As Auckland District Court choose to record us via CCTV for security, we too shall do the same. Do not presume or assume you or any other man or woman acting within a representative capacity has any right to tell us what we can or cannot do. This would be incorrect. Auckland District Court has been notified of our intentions. We shall ascertain the name of the mystery judge when we attend. We may see you then. And that's where I left it, at 1 o'clock in the morning. It is now the 11th of July, so 2 days time, it's Tuesday, and in 2 days time I'll be there with bells on, with many cameras. So I suggest either Auckland District Court either pulls their finger out of their ass and stop acting like they've got something to hide, stop acting like they have some control over me, because they don't. I'm there to discuss an allegation made by the police. I'm not there to be bullied, kicked around and told what to do. And in fact, as you guys are the public servants and I'm the public, guess who's in the lower rung? So I would suggest that if there are any more comments about me discussing things with judges, the fee schedule's there, it will be activated, and that's the end of it. I'm not interested in talking about recording. It is a right. I'm going to be exercising it. If a judge wants to play all high and mighty with me, then I'll deal with that matter at the time, and I'll deal with him, her or them personally at the time. They may think, being a judicial officer and being in a House of Representation, that they cannot be held accountable for their own actions. Dead wrong. Sorry guys. This is the reason I record things. This is the reason I make sure everybody knows. It is for maximum accountability and transparency. I've given you intent of what I'm doing, and it's for you to turn around and say I can't and prove it with some evidence. Using fear, coercion, intimidation doesn't work with me, because I'm not fucking scared of you guys. It's that simple. You derive all of your authority by bits of paper and words written on them. And unless you can explain that shit to me in a language I comprehend and not legalese, you got shit show in hell of trying to gain any sort of authority over me. Now, as far as I'm concerned, the court reference number is to do with a speeding ticket. End of. A prescribed application that I signed up for many years ago that's still being used to extort money out of me for victimless crimes, and for doing 94 on a 100k/hour motorway. So, see you Thursday, and if I get any more emails from you, Georgina, I'll just start picking up the phone. This will be recording, and I'll start asking for the building services manager and discuss shit with him. See you then. Bye.